Hello, everyone. Welcome to our HR Law webinar. Many thanks for joining us this morning. Just to introduce myself and the other speakers first, I'm Sasha Schoenfeld. I'm the head of our immigration team here at Fox Williams. And I'm going to be speaking to you about immigration and sponsorship, specifically about the white paper. And following that, one of our partners, David Butler, will be talking to you about the new corporate criminal offence of the failure to prevent fraud. And finally, our partner, Lucy Sorrell, in our employment team is going to be speaking to you about the ramifications for the Women's Scotland Supreme Court ruling. Just a few admin points first. The webinar is going to be recorded and it's being made available to those who've registered but are unable to join us this morning. Just also to make you aware of our employment tech survey, which explores how HR, legal and executive leaders in the tech space are navigating people and employment challenges. 4 questions are going to appear on your screens, which you can answer during the webinar if you'd like to contribute. We're very happy to take questions on the topics under discussion today, but if you could please put these in the Q&A box rather than the chat box. We'll aim to cover these in the Q&A session at the end once the speakers are finished. And for any questions we don't get an opportunity to answer in the webinar itself, we'll come back to those following the session. So let's get started. Just first of all, to talk about the government white paper and what it principally is dealing with. The government introduced this. They published it on the 10th of May 2025. They called it Restoring Control over the Immigration System. It's aimed principally at reducing net migration and reshaping the pathways to settlement, permanent residence and citizenship. The white paper, as I'm sure you've read, has been hotly anticipated, sets out a number of really very significant changes to the UK immigration system. And I guess the first thing to say, which is important, is that these changes are not certain as yet. Many of them are going to be subject to consultation, and they're also likely to be implemented in stages. So the purpose of these and the overarching principles is to reduce net migration principally. There'll be a focus on skills and contribution. The government are concerned that immigration access be tied to economic value, to skills and potential integration. And they want to strengthen systems to prevent abuse, ensure compliance and protect workers. And they've also confirmed that they'll be moving away from court-led changes. They're going to introduce these changes in robust legislative frameworks rather than, as they've done before, based on case law. So they're going to be parliamentary-based, clearer rules. So what's going to change for employers and sponsors specifically? Many of you, I think, will probably be licensed sponsors. And I think you may well, therefore, have read about one of the most high profile changes they're proposing, which is increasing the skills threshold. As you'll be aware, currently, workers can come to the UK if they have a job offered to them at an administrative or A-level standard. They're going to increase that to so-called RQF level 6 degree level. So they're reversing the post-2020 liberalisation, and it'll be harder to qualify for a certificate of sponsorship. They're also going to be increasing and maintaining the increase in the £38,700 salary floor. There will be sector-specific going rates. These are going to be calibrated by the Migration Advisory Committee. They're going to abolish the immigration salary list, formerly known as the shortage occupation list, because all jobs are going to have to meet new thresholds unless they're added to the temporary shortage list, which is a sort of new version of the shortage occupation list, dealing with time-limited permits for lower skilled roles, particularly those facing acute shortages. And these, importantly, won't lead to settlement. There are going to be a number of transitional protections put in place for people who are here already. with certificates of sponsorship. So current sub-degree holders can continue under the old rules, but anyone coming to the UK is going to be subject to these stricter criteria. But again, I'd emphasise that this is yet to be confirmed. So just to run through a few of the changes with regard firstly to students and graduates. So many of you may well employ the people on graduate visas in your organisations, and those post-study visas, which are aimed at graduates who have from UK universities, the time period during which they can be employed is going to be reduced to 18 months from 2 years. They've also confirmed there's going to be much stricter sponsorship rules for students and post-study work visas. They're going to curb lower-tier educational institutions, and they're going to impose a 6% levy on international tuition fees, meaning that there'll be fewer students available to work. So they have mentioned further restrictions in the graduate, student and other study-related visas, particularly with regard to dependents of students. And post-study paths for dependents are going to be significantly reduced, if not even abolished. On family routes, also some significant changes. They're going to enhance the English language requirements. All adult dependents of any family members coming to the UK will need to prove their language ability. They don't currently need to do so. And there'll be higher salary thresholds for those who want to bring a spouse or their children to the UK. There'll also be some outright bans on dependents in some lower skilled roles or sub-degree occupations. And policies are going to be applied across the board. It's unclear whether the changes will impact those already in the UK or only new applicants, and that's something that's obviously of great significance to those who are currently here. And we expect that to be clarified, hopefully later this year following the consultation process. So the next thing I wanted to talk about was the very high profile changes that they've talked about to indefinite leave to remain settlement and citizenship. This has had a lot of press coverage, but the default qualifying period that they're proposing for settlement, indefinite leave to remain, is going to be extended from 5 to 10 years. And this is only going to be if it's earned through meeting specific points-based criteria relating to contributions to the UK economy and society. We've got no detail as yet as exactly what those points-based criteria might be, but the government have stated that the existing 5-year qualifying period for all non-UK dependents of British citizens is going to remain, so long as they continue to meet the requirements to remain as a partner. So that it's a little bit easier on the dependents of British citizens, but more difficult for those coming in as skilled workers, for example. But there are unresolved questions as to dependents. Will they be eligible for settlement if the main applicant meets the points test, or will they need to meet the points test themselves? And obviously that has implications for children who are currently unable to settle unless both parents have been granted settlement or citizenship. And another question they haven't answered is the indefinite leave to remain for the accelerated routes. At the moment, you can apply for indefinite leave to remain having spent 3 years in the UK under the Global Talent or Innovator Founder routes. They haven't confirmed whether that is going to remain. So, as I say, consultation process to take place later this year. Hopefully that will become clearer. I've set out the change and what they mean and the impact of any change here in this table. It's pretty self-explanatory. I guess the ones I'd want to focus on a bit are, how much more emphasis is being placed, for example, on English language tests. That will add a quite considerable cost and complexity, particularly for the family members of applicants. And the other thing I'd want to emphasise are the lower qualifying periods for indefinite leave to remain, 10 years now, and that would mean that dependent indefinite leave to remain particularly is going to be delayed significantly, and people are going to have to renew visas more times. They're going to have to pay more, they're going to have to plan ahead for their families, and salary and financial barriers are also going to be imposed. And it's always worth remembering that costs will go up, worth factoring that in when you're thinking as employers about the future. So what to consider as an individual, I've set out here, just some tips. Apply as early as possible, really important to do so, ideally before new rules are introduced, to limit time and cost implications. And, important to consider timing and implications of this earned settlement and possible changes to citizenship provisions. Anybody who's thinking of applying for citizenship at any point, I would advise doing so as soon as they can, rather than delaying it for any reason at all. And do the same for any family members who may be dependent on the applicant's immigration status. And important always with the Home Office, prepare for possible delays or changes in the route to settlement or citizenship, and consider contingency plans if your timeline's affected. As an employer or sponsor, really important to ensure that your HR and legal teams are briefed on the changes and they're ready to advise staff, because people are already concerned and confused. We've had a lot of inquiries and we're not able to provide any certainty, but it's important that people are able to plan ahead, so to let them know what they could have to consider, and communication with affected workers and encouraging them to stay informed, providing reassurance. All of those things are really important in order to deal with the potential impact of changes. And I suppose being aware of the potential for increased staff turnover in UK employer workplaces, and the importance of adjusting workforce planning accordingly. Again, best to do that as early as possible. So just top tips here. As I say, key issues: plan any recruitment, manage expectations. I always advise sponsor license holders to do this on a regular basis anyway, but now more important than ever, in order to foresee how your license might be affected. Now's a good time to undertake a housekeeping task, to review your license, check the details are up to date, make sure you understand what your future requirements might be to make applications as soon as possible. I'm sure most of you are aware of the digitalisation of the UK border. Make sure travelling staff are aware of that, because, again, that could change and could become more stringent. Haven't been informed of that, however. Right to work checks, make sure you're up to speed. And finally, I'd always say again and again, costs. Plan ahead. These are likely to rise. Be aware of penalties and restrictions for non-compliance, and also basic costs for making initial applications. These are likely to go up in the coming months. That's all from me. I'll hand over now to David.
Thanks, Sasha. As Sasha noted, I'm a disputes partner and I head up the fraud and asset recovery practice here at Fox Williams. And I'm going to be talking to you about the failure to prevent fraud offence, which is coming to a court near you from the 1st of September 2025. There's a lot to cover, so let's get straight into it. The offence is created by Section 199(1) of the Economic Crime and Corporate Transparency Act, and it provides that a relevant body, which is a large organisation, is guilty of an offence if, in a financial year of the body, a person who is associated with the body commits a fraud offence intending to benefit, directly or indirectly, the relevant body or any person to whom or to whose subsidiary undertaking the associate provides services on behalf of the relevant body. So I've highlighted some of the relevant elements of the offence, and we'll have a look at those on the next slide. So a relevant body is any company or a partnership wherever incorporated or formed. So your Delaware LLC is a relevant body for this purpose, as is your Cayman Islands company, as is your English Limited Liability Partnership. A large organisation is an organisation which satisfies any two of the following three criteria: turnover of more than 36 million, balance sheet of more than 18 million, a number of employees of 250 or more. For parent undertakings, that calculation is done on the basis of the aggregate value of each member of the group. And if you're thinking to yourself, well, I'm a small subsidiary of a larger organisation, the government's thought about that too. And if you are the subsidiary of a large organisation, there is a special offence which has been created just for you in Section 199(2) of the Act, which says that you can also commit failure to prevent fraud and be treated as if you were a large organisation. An associated body is defined as employees, officers, agents, subsidiaries, or a person who performs services for or on behalf of the body. And that's quite relevant because agents that provide services to the relevant body will not be included within the scope of the offence. So it's be very important for you to check what your agents and what your service providers are doing, whether they are providing services to you or services for or on your behalf. The associated person must commit a fraud offence, which is intended to benefit the organisation. So the offence is not committed if the organisation is the intended victim of the fraud. The offence is extraterritorial in scope, and that's because certain of the fraud offences can be committed if any part of the offence is committed in the UK. So a fraud offence can be committed if the harm occurs in the UK, for example, or if any other relevant act occurs in the UK. And so if you're thinking that the fraud only has a passing relevance to the UK, that doesn't matter. The large organisation can still be caught by and guilty of the offence if it's involved in the fraud and or fails to prevent it. These are what the statutory fraud offences are at the moment. I'm not going to deal with them in great detail, but you'll see cheating the revenue, false accounting, false statements, offences under the Fraud Act, all of the different types of fraud under the Fraud Act, obtaining services dishonestly, and also aiding, abetting, counselling and procuring any one of those offences as well. And while the prosecution would have to prove the underlying fraud and therefore would have to prove the act and the intention on the part of the defendant to commit the offence, liability for the failure to prevent fraud offence is actually strict. They don't have to prove that senior management knew or was involved or connived in the offence in any way. All they have to prove is that a fraud offence was committed and that you failed to prevent it. I've included here some examples of who would be within and who would be without scope of the failure to prevent fraud offence in terms of those who provide services to the company, and a couple of associated person examples. I'm not going to go into those in any detail because time doesn't permit, but they're there if you'd like to look at them afterwards. Moving on to the statutory defence that's created in section 199(4) of the Act. And it says it's a defence for a relevant body to prove at the time of the fraud offence was committed that the body had in place such prevention procedures as it was reasonable in all the circumstances to expect the body to have in place, or it was not reasonable in all the circumstances to expect the body to have any prevention procedures in place. And section 199(5) of the Act defines prevention procedures as procedures designed to prevent persons associated with the body from committing fraud offences. And section 204 says that the Secretary of State must issue guidance about procedures that relevant bodies can put in place. The Home Office did issue guidance on the 6th of November last year, and we'll come and have a look at that briefly. You can find that on the Gov.uk website, and in fact UK Finance has also produced some very helpful guidance too for the finance industry. Reasonable prevention procedures, fraud prevention measures should be designed with reference to the organisational structure and the extraterritorial scope of the offence. So if you have a far-flung organisation with various different entities in lots of different jurisdictions, obviously your approach will differ and must differ from if you're a purely UK-centric organisation. If you do have groups, the guidance suggests that you should have group policies and procedures and then nominated individuals within each entity who have responsibility for fraud prevention in each member of the group. Be sensitive to compliance with local laws and local jurisdictions, because there may be issues about confidentiality or privacy laws in certain jurisdictions which limit your ability to implement procedures universally. The level of control, proximity and supervision of others is relevant. So for parties in an extended supply chain, you might have a relationship with the main contractor, but subcontractors further down the chain you'll be less proximate to and you may have less control over, so you need to be mindful of those relationships. And the defence of it was reasonable to have no procedures in place at all is unlikely to find any favour with the jury if, in fact, you didn't consider whether you needed to have any reasonable procedures in place. So it won't be a defence that will be capable of being taken advantage of in many situations, I would suggest. The guidance identifies 6 principles which should inform the fraud prevention framework adopted by entities. And to be fair, the government, I think, does expect large organisations to do quite a lot of work to ensure that their fraud prevention measures are reasonable. A top-level commitment is the key and the sort of the cornerstone around which all of the rest of this is built. And the government expects the board to set the tone and have a zero tolerance policy in relation to fraud, and to ensure that that's properly instilled in the workforce, and that whistleblowing is encouraged and dealt with appropriately. It's expected that senior management will provide the adequate resources that are adequate to deal with fraud, and training, and also people with knowledge and responsibility for conducting assessments of risk and devising fraud prevention measures. It may be necessary, the guidance suggests, to identify the parts of the organisation which have the greatest opportunities to commit fraud. And that can be determined by reference to numerous factors, from the nature of the work done by those parts of the organisation to how easy it is to identify potentially fraudulent activity in those parts of the organisation. Measures should be proportionate to the risk, and they should take account of the level of control and supervision the organisation is able to exercise over particular associated persons acting on its behalf. In terms of due diligence, the guidance suggests using a technology, including AI solutions, third-party risk management tools, screening tools, internet searches, thorough reviews of counterparty trading histories, and professional and regulated status and reports from regulated bodies where that's appropriate. And finally, on monitoring and review, I think that probably speaks for itself, but the organisation that adopts a risk assessment on the 1st of September and never reviews it is unlikely to be able to prove that the measures were reasonable in all the circumstances. Hope you followed that, and with all of that, I'll hand over to Lucy.
Thank you so much, David. This is a very complex matter to discuss in the time remaining, but I'm just going to summarise where we are with this decision, the For Women Scotland decision, as well as some key latest developments on this matter. So those on the call will probably be aware that For Women Scotland was a Supreme Court case which looked at whether the definition of woman in the Equality Act should be restricted to define those whose sex at birth was female, and so as to exclude those with gender recognition certificates changing their sex to female. And sadly, there's no time to go through the detail of the judgment in the time available, but in summary, it was decided that the definition should be restricted in this way, and that obviously has potentially very wide-ranging ramifications under the Equality Act, including in relation to things like positive action, data collection, and most controversially, probably single-sex facilities in workplaces and public spaces. And so some of the key implications for employers are that, well, I think probably most importantly, a number of their policies, including around changing rooms and toilets, will eventually need to be reviewed. And I'll come back to this in more detail later. There's other implications, such as excluding trans women from practices around positive action. I think also, given the polarisation of people around this topic, employers have had to be quite mindful of employees with conflicting views and how to manage that challenge in the workplace. And helpfully, we've just published an article on this in the latest edition of HRLaw, if you want to read up on that further. So after the judgment, the EHRC very quickly rushed out some interim guidance on the issue of single-sex facilities, which is on the slide. And the guidance adopted a very strict approach, seeking to make clear that it's compulsory to have single-sex sufficient single-sex facilities, and trans women and men should be excluded from the toilets pertaining to the opposite biological sex. It seemed to suggest that employers just needed to make sure they had single-sex toilets and excluded the opposite biological sex, and that was the key priority. That's been subject to a lot of challenge and has since been softened by an update which was issued just yesterday, which is on the next slide. We've just put the sort of changes from yesterday on the slide, and you can see that the emphasis has been taken off single-sex toilets, and there's more emphasis on the fact that it's possible to have mixed facilities where they are in a separate room, lockable from the inside. So it's not a big shift from what was being said before, but it's sort of placing more emphasis on this workaround, which is that you can have mixed sex facilities in separate lockable rooms. And that reflects the position under the workplace health, safety and welfare regulations, which are on the next slide, which just make clear that employers can either have single-sex toilets or mixed-sex toilets in separate lockable rooms. So the guidance is being brought into line with these regulations. So in terms of where this leaves employers, really we're waiting for the final guidance, which is currently subject to consultation. I'll talk about that in just a moment. And it would seem prudent to get the final guidance before any definitive updates to the policies are made. Some employers are issuing their employees with a kind of holding statement to say that they're awaiting that guidance before they review their policies. In the meantime, I think the focus has been on repurposing toilets in individual locked rooms as explicitly mixed sex where that's possible. So it might be that those individual lockable rooms were disabled toilets and they're being repurposed as mixed sex toilets, or they might just be toilets in individual lockable rooms which are allocated to one sex only, and that's slightly changed so that they are the mixed sex. It's more difficult for employers if they don't have the individual lockable rooms, and we'll just have to wait and see what the guidance says about that and whether there's any sort of further flexibility or workarounds on that point. So this is the last slide, and it's just to touch on the consultation that's ongoing. The consultation opened on the 20th of May and it's set to close on the 30th of June. So there's still time to have a look and input into it. This guidance, the draft guidance, relates to discrimination in goods and services, public functions and associations, but it will be highly relevant to employers as well. So it's well worth having a look and familiarising yourself with that. The guidance touches on a number of themes which will be really of great interest to employers. So in relation to single and mixed sex spaces, there's a lot of examples given in the guidance, and it's interesting to note that the emphasis is on kind of proportionality and balancing the risk of discrimination to different groups. So trans people and people of a particular sex, and the guidance gives a range of examples applicable to different situations. It's quite clear that there's no one-size-fits-all permissible solution. It will depend on all sorts of factors such as the organisation's resources and the risk of harm to different groups in particular situations. I did note one quite interesting example in the guidance which suggested that it might be possible in some circumstances to have a mixed sex facility where there were floor-to-ceiling lockable cubicles, which is a little bit different from what the current guidance is saying, and that might offer some welcome flexibility. There's some interesting new examples as well of discrimination or harassment by perception involving trans women. So where trans women are discriminated against where they're perceived to have biological female sex. And an interesting new example of indirect discrimination involving a trans woman suffering the same disadvantage as women. So would encourage you to have a look at the draft guidance and feedback on it. And that's it from me. So Sasha, I don't know if you want to just wrap up.
Yeah, thank you very much, Lucy and David. And thanks very much for joining. As I said earlier, if you've got any questions, please do put them in the Q&A box. We'll be happy to answer those directly or email us anytime. And just thank you very, very much for joining. Take care. Bye.